Mr. Deputy Speaker, on behalf of the Deputy Prime Minister and Minister for Trade and Industry, I move that the bill now read a second time. Mr. Speaker, as a small and open economy, our business's ability to move goods swiftly and securely across borders is crucial for maintaining our competitive edge as global trade hub. Today, we are proposing amendments to the Regulation of Imports and Exports Act 1995 to strengthen the integrity of our trading processes and enforcement capabilities. This will reinforce Singapore's status as a trusted and reliable global trade hub. Allow me to share the two key proposals of this amendment bill. First, the bill will strengthen our regulatory framework for the issuance of trade information certificates. Second, the bill will facilitate Singapore Customs' investigative powers to uphold the integrity of Singapore's trade regime. Our first proposal is to introduce a new Part 3 to the Act to provide further legal and regulatory certainty for the issuance of trade information certificates. Trade information certificates are documents used by businesses in international trade to ascertain certain information about goods. An example would be information on the country of origin of goods. To be clear, trade information certificates issued locally are not mandated by the Singapore government for the trade of goods. However, our local exporters often require them, as the certificates can be requested by the regulatory agencies of other countries or their commercial partners. Currently, Singapore Customs and relevant regulatory agencies in Singapore issue these certificates. Trade information certificates may also be issued by authorized non-governmental organizations. For example, Singapore Customs has authorized 5 trade associations and chambers to issue certificates of origin to businesses that require them for commercial purposes. The bill provides for other eligible entities to be authorized as alternative issuers of trade information certificates while ensuring the integrity of the certificate issuance process. The bill also introduces offence provisions for issuing false or misleading trade information certificates or tampering with these certificates. This is to deter any person who has an intention to falsify or tamper with trade information certificates. In addition, with the amendments, it will be an offence if an individual makes false declaration or provides false information to Singapore Customs or authorized certificate issuers in the application of trade information certificates. Under the existing Act, an appeal may be made to the Minister in respect of any matter mentioned in the Act. The new Part 5 of the Act expands on this and enables the Minister to designate a representative to hear and determine any such appeal to ensure that appeals may be dealt with expeditiously. Such representatives may include Second Minister, Minister of State, or Parliamentary Secretary. Essentially, these amendments help to preserve Singapore's reputation as a credible trade hub by ensuring the legitimacy of our trade information certificates. Our second proposal seeks to enhance Singapore Customs' operational effectiveness through amendments to facilitate the investigation of offences and expand the scope of situations for granting a search warrant. Currently, Singapore Customs can apply to a magistrate for a search warrant to enter premises to investigate offences under the Act. To do so, Singapore Customs is required to reasonably prove that premises contain goods relevant to the investigation. However, there have been instances where Singapore Customs was not able to obtain a search warrant as it was only made aware of the potential offence after the goods had left Singapore. Nonetheless, the premises may contain other evidence useful for investigations, such as books, documents, and records related to the potential offence. Clause 10 of the bill expands the scope for granting a search warrant to include circumstances where Singapore Customs have reasonable proof that the premises contain other forms of evidence related to the potential offence under this Act. Foreign jurisdictions such as Hong Kong and Australia have similar laws. Clause 10 also enables Singapore Customs to inspect relevant computers or associated devices found at the premises, and preserve any relevant books, records, or cash that could be evidence of an offence under the Act or its regulations. Clause 13 builds on existing provisions of the Act to make it an offence to alter, suppress, conceal, or destroy books, records, documents, or other articles with the intent to delay or obstruct the conduct of investigation. The amendments to Singapore Customs enforcement powers under the bill are aligned with similar provisions in the Customs Act. I would like to assure members that such powers will only be exercised in the interest of facilitating Singapore Customs investigation of offences. The amendments will enable Singapore Customs regulatory and enforcement operations to be more effective and also strengthen the deterrent effect for offences under the Act. In closing, the amendment bill seeks to strengthen legal and regulatory framework for the issuance of trade information certificates in Singapore, as well as to facilitate Singapore Customs investigation of offences. These efforts will ultimately strengthen Singapore's status as a trusted and reliable global trade hub and a responsible trade partner on the global stage. Sir, I beg to move.